So this is an introduction to business torts of relevance to advertising law. This section of the course moves beyond basic false advertising to other things an advertiser should know about in making decisions. Sometimes, as with the materials from today, there's an intersection with falsity. Sometimes the concerns driving the relevant bodies of law are orthogonal or tangential to the concerns driving false advertising law. And you can consider how the divergence shows up as we move along. For today's materials, some history is pretty important. The move to bring greater First Amendment scrutiny to defamation law and to pay more attention to the difference between saying false things and saying mean things about the competition or about oneself means that both constitutional law and regulatory law have changed focus from mean things to false things. This means that we now, on the regulatory side, encourage comparative advertising, and among other things, we don't extend trademark law to prevent talking badly in the absence of falsity about the competition. The torts we'll consider today mostly involve the defendant's statements about the plaintiff's products, not statements about the defendant's own products. The potential exception is tortious interference with existing or prospective economic advantage. You should just be aware, basically, that tortious interference is an existing tort. It's really hard to win, and it's slightly easier to win if the allegation is interference with a specific existing contractual relationship. Unless the market is small and an individual sale requires individualized selling and involves at least tens of thousands of dollars per customer, when I see a tortious interference claim alleged, I usually just think that the plaintiff's lawyer is just running up the bill, frankly, and annoying the clerks. So the summary on screen shows the key differences between the common law torts of defamation and disparagement versus the Lanham Act and state consumer protection claims. Because the Lanham Act and state consumer protection law in general are strict liability, they are generally broader in coverage as applied to commercial speech. By contrast, defamation and disparagement claims can be brought by anyone against anyone, and the Supreme Court has held they cannot be strict liability. They're broader in coverage of possible defendants. The jury is the fact finder, and no extrinsic evidence of deception is required for the deception element. So that's a potential difference from at least some of the Lanham Act claims. Fact versus opinion is the relevant divide. As to the actionability of opinion, old cases say that opinions are actionable, but today the treatment is highly similar to that in consumer protection cases. Opinions are actionable if and only if they imply specific defamatory or disparaging facts. A representative quote from a libel case is, even if the speaker states the facts upon which he bases his opinion, if those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact. There is also an analog to a puffery defense in disparagement law. There is a privilege that is laid out in the restatement section second of torts 649 to make an unduly favorable comparison of quality, even if the seller doesn't believe that its own goods are in fact superior, if the comparison doesn't contain false assertions of specific unfavorable facts regarding the rival competitor's goods. This is a conditional privilege, that is, it exists in the absence of malice. One thing to consider is, given what malice requires, which is some level of scienter about the falsity of the statement, how could you ever make a puffing claim maliciously? Is that even possible? Or is the specific false claim part and parcel of what it means to have malice under the current definition? The rationale for this defense, or privilege, I should say, is that many buyers recognize disparagement as inherently non-objective and highly biased. So now a little bit of terminology. We have defamation, which goes to the plaintiff's character. It includes non-pecuniary interests, that is, interests in dignity and personhood that can't be clearly cashed out into sales, versus disparagement or injurious falsehood, or trade libel, travels by several names, which deals with only pecuniary interests. Pecuniary interests can be harmed by ordinary falsehoods, like statements that one competitor's goods are better than another's. Defamation requires something more, like people refusing to do business with you because someone said your goods were stolen. So the set of defamatory statements is smaller than, though regularly overlapping with, the set of disparaging statements, since saying that goods were stolen could well constitute both disparagement and defamation. Because non-pecuniary personal interests were traditionally thought to be more important than economic interests, it used to be easier to make out a defamation case once the statements fell within the class of potentially defamatory statements than it was to make out an injurious falsehood case. Among other things, it used to be true that falsity and lack of privilege could be presumed in defamation, whereas they needed to be proved for injurious falsehood. With the rise of First Amendment scrutiny of these torts, the difference has largely fallen by the wayside. In addition, we now tend to recognize economic interests as at least as worthy as non-economic interests, sometimes more so. So the justification behind the special treatment for defamation has eroded. The only significant remaining difference is in damages. Damages can be presumed in a subset of defamation cases, known as defamation per se, whereas they must be shown in every case for injurious falsehood, and this is known as special damages. The presumption of damages is extremely valuable because it allows the plaintiff to get a verdict in his or her favor in the first place, since damage is an element of the tort. In addition, actual damages for lost reputation can be pretty large in practice. A jury that rules for the plaintiff tends to be pretty angry at the defendant, although there is a distinct subset of verdicts in which the plaintiff is awarded only $1 in nominal damages, as you can see in the casebook with the Boulay case. Special damages for disparagement and so on means a pecuniary loss that has been realized or liquidated, as in the case of specific lost sales. However, this is not a uniform rule across jurisdictions. Some jurisdictions, for example, accept that the cost of litigation to show that one's products are actually good itself counts as special damages. So they'd always exist. Last but not least, just a quick summary of the elements of injurious falsehood. The key things here are that there has to be intent or negligence as to the harm to the plaintiff, and then knowledge of falsity or recklessness as to the falsity of the statement, which is this part number 2 is known as actual malice. And from there, we have teed up the issues for discussion in class. Thank you.